So if you follow our news out, you know that the issue of judicial reform has been front and center here for many years. Lately, though, it has become a huge issue at the South Carolina State House and beyond. We are here today with somebody who can make a huge difference in this debate and who is making a huge difference in this debate, Attorney General Alan Wilson. General, thank you for being here.
Thank you for having me, Will. I really appreciate it.
Before we dive into the issue, though, I wanted to ask you, you hear general a lot, but you've got another title, don't you? Another rank.
I'm a colonel in the National Guard.
That's right.
27 years now. So still going.
So now you're going to be a general in there one day?
No, I don't presume anything. I'm going to do my job, and if I get the opportunity, great. If not, that's fine too.
Well, let's dive into this issue. A lot of folks have come in here, sat in the chair where you're sitting, lawmakers, solicitors, sheriffs, other law enforcement leaders. And I've tried to ask them a similar question to start this discussion. When did it first start to dawn on you just how bad South Carolina's judicial branch had become? How, I don't want to say corrupt, but yeah, let's call it what it is. I mean, this is a system that is not working for the benefit of public safety, for the benefit of victims. When did it start to dawn on you just how serious the problem had become?
Well, I've been doing this job now for nearly 12, 13 years, and I've been involved in lots of cases over the years, and you start seeing anecdotal examples, you start to see little red flags, they start to snowball, and pretty soon it almost becomes impossible to ignore those red flags. I have 90 lawyers in our office that are traveling throughout the state, and they talk to lawyers, they report back what they see, what they observe, and pretty soon it just becomes impossible to ignore.
Well, give us a few of those anecdotes if you can. You don't have to cite cases or anything, but what are some examples?
Well, before I cite some anecdotes, let me frame the issue rather at kind of a 50,000-foot level. And I've heard other people say this, but I'm going to start here. In South Carolina, we have a system of government where there are three branches: the executive, the legislative, and the judicial. And in the process of selecting the judges who sit in the judicial branch of government, the executive branch of government has zero influence, zero input. When you're talking about equal checks and balances on our system, that does not exist here. There is no way for the executive branch of government to have input into who gets to serve as a judge in our judiciary. With that being said, the current system is basically designed in law and in Constitution that there's this thing called the Judicial Merit Selection Commission, the JMSC for short. The JMSC has 10 people on it, okay? 10 people. All 10 people are appointed by the legislator, and 6 of them are actually serving members of the General Assembly, okay? Lawyer legislators even, okay? So the General Assembly totally controls the screening and vetting mechanism and the nominating mechanism of the judges, and then the General Assembly in turn gets to vote on them. At no point in the process for selecting a judge does the executive branch have a say. Does the executive branch gets to weigh in? And this is why I think that's important. Normally, on a day-to-day basis, the legislature passes the laws, the executive branch enforces the laws, and the judiciary interprets the laws. Everyone knows that who graduated from third grade civics. So on a day-to-day basis, the executive branch is the only branch that appears every single day in front of the judiciary. We're the only branch, whether it's in the form of a prosecutor, or a law enforcement agency, or a state agency director, or a local agency director. People who reside in the executive branch enforce the laws and the ones that get challenged in court, either in the criminal justice system, when someone is being prosecuted, or maybe when they're enforcing a law that some citizen doesn't agree with. The executive branch is constantly getting sued and having to go before the court. Now, I know there are lawyer legislators that appear in the court, but they're appearing in their, professional, personal capacities, not because they're a member of the legislature. And with the exception of a high-profile case like the heartbeat bill or some major law that is passed that gets challenged in court, the General Assembly generally does not appear in front of the courts. It is the executive branch. The executive branch yet appears before these courts but has no say in who those judges are. Zero. And so there's an incredible imbalance of power. And so if you think about it, Will, all the power for selecting and electing judges has been consolidated in one branch of government, while all accountability for those or for that power has been dispersed. So there's nowhere to go if you're angry that a judge is doing things that is harmful to your community or not following the law or is ill-tempered. There's no way for the general public to go to. So what I'm advocating for, and I'll go to my anecdotes in a second, but what I'm advocating for is a system where power is split 50-50. We're not wanting more power than the legislative branch of government. We think the legislative branch of government should be equal partners in the selection of judges, and we think we should be equal partners with the legislature. And then at the same time, we think both branches should be equally checked by the judicial branch. I want the judicial branch to have an equal check on the power that I have. I want them to have an equal check on the power of the legislature. But we don't have an equal check on the legislature, and we certainly don't have an equal check on the judiciary. And I think by bringing the executive branch to the table and how judges are selecting and giving us equal power is a great way to start. It also gives the people more direct accountability in who is sitting on the court, because it is easy to be angry at a individual governor or even an individual attorney general than it is 170 members of Congress of the legislature, excuse me. You can vote against your House member or your senator, but the other 168 you don't have any control over. So the accountability is not there. So that is systemically the problem, that we don't truly have an independent, judiciary in the sense that one branch of government completely controls who sits on the bench in the other branch of government and then funds them. With that being said, a couple of anecdotes. So as I've traveled the state, I'll give you a couple. The first anecdote is a young woman who sat on what's called the Citizens Advisory Committee to the JMSC. I think the bar has a committee. There's citizen advisory committees around the state, and they are able to review applicants. So when, let's say, a vacancy occurs in either the family court circuit, Court of Appeals, or Supreme Court, judicial candidates put their packets in. Those packets are allowed to be vetted by the bar and also by the Citizens Advisory Committee. And then those citizens get to make comments to the JMSC on they get to give the JMSC their opinion. And the JMSC is supposed to factor that into their decision on who to rate out as qualified or most qualified to go before the General Assembly.
And this is that panel, again, controlled by the lawyer legislators.
The JMSC, controlled by the controlled by the legislature, period, but specifically lawyer legislators. Well, I was talking to a woman who came up to me after I gave a speech at a local chamber meeting, and I talked about this very issue. And she says, Mr. Wilson, I want to give you an example. I sit on the Citizens Advisory Committee. And she says a couple of years ago, and I'm going to sanitize the facts because I don't want to identify the judges or individuals, but there was a person who was applying for a judicial position. This person had zero experience in that particular type of court. They had never practiced that type of law. They had never been in that type of court. And when the commission looked at that individual's packet, they said, you know what, you've worked in state government a long time, but you have no experience in court. So before you become a judge, we would recommend you get a couple years' experience and come back to us. So they ranked this individual as unqualified. That person packet got referred to the JMSC along with a bunch of other packets. The JMSC not only selected that individual as one of the three most qualified that went before a full vote of the General Assembly, that person actually got elected to the bench, to the seat that they were applying for. And they were found unqualified because they had no experience. It was because of who that person was and who they knew, I believe, that is kind of what gave them the edge. It had nothing to do with their background. And so how do you hold people accountable for that?
Yeah, so much for merit in that situation.
Right. And that that incensed me. And this woman who was a member of the Citizen Advisory Committee, she said it really shook my faith in the system. And now that you're talking about it, she says, I really appreciate this. But she's not a lawyer. But she just said, I know enough about law that if you're going to be judging people appearing before you, you need to have at least been in a courtroom. And so her faith was shaken by that. Then I talked to attorneys around the state. Couple of examples. One attorney was appearing in court, and they were there to, I don't know if it was a motion hearing or a plea, but a lawyer legislator walks in open court. The judge is holding court. The attorney was there waiting to meet with the lawyer legislator. The lawyer legislator walks in, points at the judge, snaps, and says, Chambers, now. And the judge basically recessed for a few minutes, went back to meet with the lawyer legislator in chambers, and then they came back out, resumed court, and then the lawyer legislator met with the attorney friend of mine who then appeared before the judge. That person had no clue what they talked about in chambers, but that lawyer legislator was only there to deal with that particular case. So, to walk in, snap your fingers at a judge, and tell them to go back to the chambers, and then they just scurry off the bench, that's unnerving. It's unsettling. I could give you other examples. One other example, another attorney friend of mine is in open court a couple of years ago having an argument in front of a judge with a lawyer legislator. They're trying to determine what to do on a particular case. The judge says, let's pick this up next week. You guys need to get some more information. We'll reschedule. The lawyer legislator said in open court, well, I'll be in Columbia next week dealing with the JMSC in which your file is pending in front of. And it was like total shock in the room, the brazenness that lawyer legislator would say that in open court. And the attorney I was talking to was like, I just couldn't believe it. It was like a mic drop. So those are anecdotes, and I could probably give more, but those are just a few that illustrate that there's a perception issue at a minimum, if not direct influence on a worst case scenario.
I wanted to ask you briefly about one of those examples, and I know you won't be able to talk about every detail of this case, but back in April of this year, our news outlet reported that a convicted killer, a gang leader, had been improperly released from the Department of Corrections by a retiring circuit court judge. This gang leader was represented by a powerful lawyer legislator. This individual was released on a sealed order by this judge. And it struck a lot of, not just us, it was one of those moments where I think everyone who looked at that situation, because this individual had been sentenced to a mandatory 30-year sentence. He was supposed to serve 35 years, supposed to serve every single day of that sentence. Now, your office was very involved in that fight, but walk us through a little bit of what you can tell us about the Jared Price story.
Well, I actually argued that case in the Supreme Court. I mean, I was that fired up about it because I just saw the injustice in it. Let me go back to the initial event. It looked horrible, and I don't think there's anything you can defend about the facts of the case. As to what motivated the judge, what motivated the solicitor, I'm not going to opine on because I'm not back in the room, okay? What I can say is that when people see stuff like that, their head goes to the darkest places when you talk about influence. It doesn't matter whether or not influence occurred, inappropriate influence occurred or not. People believe that it did. And I want a system that can make it possible for people to say, okay, no matter how something looks, the system wouldn't allow that influence to exist. Right now, our system allows for that influence to exist, whether it actually happened or not. So I'm not going to speak about the motivations of the individuals involved in that. What I will say is that all of the rules were broken. There was basically a pathway to actually have someone considered for early release, and not one single legal requirement in that pathway was considered or even followed, and it was all done, out of court. There was no legal documentation of it, and we didn't even find out till several months later, and that looks horrible, and that causes people to question the system. And then, of course, what was interesting when I was arguing the case, and look, I want to say this: thank you to the Supreme Court in a majority 3-2 decision for vacating that order and sending him back to prison. And thank God he was caught yesterday without incident, and he's going back to where he belongs. But during the arguments, well, I'm not going to say which justice, but one of the justices said, y'all screwed up, and you want us to fix it. Now, I was there as the chief prosecutor of the state to say one of our elected prosecutors didn't follow the rules, and I told that elected solicitor that I was going to say that. I was being very open with him, but the judge was in the room. The judge signed off on everything. This is a senior retiring judge who's presumed to know the law or presumed to know how to pick up a book and read the law that is in the draft proposed order, and that judge signed off on everything. And when a judge signs an order, a proposed order that is drafted by a lawyer, that judge is endorsing everything that lawyer says. And so, I just thought to myself, wow, this just it underscored under me is that we have no check on the judiciary because they were blaming us completely. Now, yes, the executive branch screwed up in that because the solicitor is a member of the executive branch. But guess what? The judge is a member of the judicial branch, and they screwed up just as bad. And I don't think anyone said anything about the judge that day. And I'm not here to besmirch that retired judge. What I'm saying is the system failed the Smalls family and let a murderer out 16 years early. And had the law been followed, that person would have never been released. And so that is a separate issue, but it does feed into the mistrust and the distrust that an increasing number of people are coming to me about when it comes to how we elect judges in South Carolina and that relationship with the legislative branch of government.
Well, let me give you a little credit on that, too. In addition to arguing that to the court, I think one of the things you did during that Jared Price saga that I thought was incredibly important was before he made for New York, apparently he was found in the Bronx, an address in the Bronx, but before he left, Richland County Sheriff's Department deputies had eyes on him. They knew where he was. And at that time, you went to the Chief Justice. I think you wrote him a personal letter and said, hey, we need to at least hold this very dangerous individual before we hear this case. Pretty risky move there to send a letter like that to the Chief Justice.
Well, first, let me say this. I'm grateful that the Chief Justice and the other 4 members of the court took up this case within days of us filing the expedited motion to have it. So thank you, court, for doing that. They did take up that case very quickly, and they ruled on it within an hour or two after we argued the case. We still haven't gotten the written order that gives us their legal reasoning in the majority decision, but we at least got the vacating of the order that sending back to prison. But I did send a letter to the court saying that this person, Mr. Price, is not only a threat to the community, he is a flight risk. And in light of the high-profile nature of this case and the fact that we are projecting that we're going to be determining his fate next Wednesday, and I'm paraphrasing, I think it would be important for the court to issue a bench warrant to hold him until such time as you make your decision. If you decide the other way, release him. If you decide to send him back to the Department of Corrections, then you've got him in custody. And I thought that was a safe thing to do. So we sent the letter to the court the Friday, like 4 or 5 days before the hearing occurred.
Let's talk a little bit about how we fix this, because clearly you've described these imbalances, these inequities, a lack of separation of power inherent in this system. Clearly there are 2 levels that we can look at as far as solving it. There's a broader, constitutional change, taking the legislature out of the business of electing judges. That would obviously require a change to the Constitution. We'll talk about that in just a sec. But in the immediate sense, looking short-term, sort of immediate effect solutions, what are you proposing right now to start to restore some of that balance to the system?
So I had a roundtable discussion the other day, and I basically kind of laid out as a starting point. I'm open to debate on it, and I'm open to a conversation on it, but I brought in and had a very good conversation with 30 members of the General Assembly. We were down at the Southern Legislative Conference in Charleston, and across the street from there at a law firm, we had an open roundtable discussion. I invited everyone. And Will, before I tell you what I proposed in that and explain in detail what I'm asking for, it's important to understand who was there. There were a handful of members of the Freedom Caucus. There were a handful of Democrats from the Democratic Caucus in both the House and the Senate, and there were obviously the members of the Republican Caucus there. So it was across the spectrum of views of people. And then, of course, when I left that event, I walked across the street and I was walking through the lobby, and a number of legislators walked up to me. House members and senators from both parties walked up to me and said, I heard you had this roundtable. I couldn't go because I had a prior conflict, but tell me what you said. And I told them what I said in it, and they were like, yeah, we agree with you. Republicans, Democrats, House, Senate, it was everywhere I went.
Lawmakers. These are lawmakers.
Lawmakers, yes. Our lawmakers from the South Carolina General Assembly. And they were from both caucuses and both bodies. And so, and I'm not going to say who because I don't want to speak for people, but there were people I was actually shocked that came up and said, yeah, I think there's a lot of common ground here. Now, maybe people based on where they are on the political spectrum are motivated for different reasons, okay? And I don't care what their motivations are, but what we want is we want reform that promotes an independent judiciary, that promotes an accountable judiciary, and that reassures the public that the system is working in their best interest, not the best interests of select individuals who have power. And that's what I really took away from that.
So what are those reforms?
So what I started off with is when you look at what the federal model is, I said what I like about the federal model and what I want, Will, is I want equal power in the election of judges between the executive and between the executive and legislative branches. The federal model, the federal system, does a good job. The president nominates, the Senate, the legislative branch, confirms. it's everyone gets to watch the vetting of all the judges in full committee. I love that. Now, while I like the federal model and I think it's the cleanest and crispest way to do this, I also recognize that constitutionally in South Carolina we're made up differently. We have to have a JMSC because the JMSC is in the state constitution. Also at the federal level, members of Congress, the Senate specifically, they don't practice law and appear in front of the judges that they elect, and the judges that they elect or confirm serve life sentences. And I'm certainly not advocating for life sentences. So the translation of the federal model to the state system is obviously clunky. So what I like about the federal system is the fact that it is equal power and it's clean, but you translate that down here, we can't do that. At least it's not feasible at this time. So what I was advocating for in lieu of that is a system that still gives at least more power, if not equal power, to the executive branch of government in the selection of judges. And what I said right off the bat, as I said, the JMSC, while it is a constitutional creation, statutorily the makeup of it is determined by law. So I think the JMSC needs to be gutted. I think the governor needs to be able to make all the appointments to the JMSC.
All 10.
All 10.
Okay.
Because we're equal partners, right? You know, this isn't the kids' table. We're the executive branch of government. Judiciary and legislative branch of government, we are equal partners. All 10 appointed by the governor, and then remove the cap of 3, and then whoever gets qualified by the JMSC gets to go up for an up or down vote by the General Assembly.
I mean, when you say, just so our audience understands, when you say remove the cap of 3, that means that the lawmakers don't get to pick their 3 favorites for each race.
All right, well great, because there's people watching that probably don't understand the process. So let's say there's an opening on the circuit court bench or the family court bench, and you have 10 people apply, okay, to the JMSC. The JMSC can vet all of the people, and all 10 can be qualified, right? But the JMSC says here's the 3 most qualified. Here are 3 favorites, and they pick their 3 favorites that get voted on by the legislature.
So that caps another way that they kind of narrow.
They can narrow it down, and the argument could be made that sometimes there's the one they want and then the 2 throwaways. I'm not saying that happens every time, but I have had legislators tell me that, 2 people got screened out, but there was a foregone conclusion. And so I've had that told to me in the past. So I would remove that cap. And if you're qualified, you're qualified. Now, I am not married to those specific, elements of reform. I'm just offering a starting point, a position. My interest, Will, is equal parity of power between the executive and the legislative branches of government. I want to couple the power of electing judges with the accountability for it. One of the reasons I want the governor, or at least members of the executive branch, I prefer the governor appointing those people, is everyone in the state gets to vote for the governor. Everybody. Not everyone in the state gets to vote for the members serving on the JMSC or the General Assembly at large. You only get to vote for your members, right? So there's more accountability in that case. Now, I've also seen there's a bill sponsored in the Senate. I think Chip Campson's a sponsor. Wes Clymer's on it. Josh Kimbrell. There's a couple of other senators on there where they basically kind of make it like the federal system. The Constitution, Article 5, Section 27, says that the General Assembly must elect candidates nominated by the JMSC. But statutorily, you can make a requirement to go to the JMSC. If you're a judicial candidate, you can make the requirement be you have to have a letter of endorsement from the governor.
So it sounds like...
And so you could basically, on the front end of the JMSC, you could give the governor the ability just to send one candidate to the JMSC. They screen him out as qualified or unqualified. The General Assembly votes on him. That is an element. That is something that I could work with because it brings parity of power. And so when I say these are my positions, these are my positions, but my interest is to equalize the power and to make the judiciary more independent and to instill public trust in the public into our system.
So you're working with lawmakers on various proposals to restore some of that balance in the short-term statutory. Let me ask you, long-term, do you support a constitutional amendment which would move South Carolina more to a federal model in terms of having governors appoint judges and the lawmakers, perhaps maybe even a joint session, maybe just the Senate, providing advice and consent? That more of a pure federal model, obviously that would have to be a constitutional change, but do you support that constitutional change?
This is going to sound like the worst political answer. That depends. So if well, I'm about to answer you. So let's say we implement some of these reforms within the current constitutional framework, and they go into effect, and there's parity of power, there's more transparency, there's more accountability, there's less appearance of impropriety by lawyer legislators appearing in front of the judges, and over the next couple of years that system starts to work and we get positive feedback, then I don't know that I would advocate for that. But if the interim reforms, the short-term reforms we're able to do, don't cut the mustard, then yeah, it'd have to be. I'm open to all of the above. You know, I've heard of people talking about retention elections, which kind of would allow. It's kind of a down ticket election. Once the General Assembly and executive branch of government put a judge on the court, after so many years, that judge would come up for a yes or no vote by the people. I've seen that work in other states. I've had people talk about it. Some people would say they don't like it because even if it's just one person on the ballot, that could invite dark money to come in and just rip them a new one. So there are pros and cons to doing everything. But I would have to say I'm open to constitutional amendments. But right now, I want something now that brings equal power and more accountability to the selection of judges. So I'm open to it. I'm open to retention elections. I'm open to a system based on the federal model, but we'd also have to answer the question, does the governor have to renominate that specific judge every 6 or 10 years? Because remember, these aren't lifetime appointments, so it's a system that has to replicate.
But as our next governor, you'll be answering that question for us, won't you?
No. As your attorney general, I am advocating for a system that the people can be proud of, that the people believe in, and the system that the people trust. I've got a lot of good friends in the General Assembly, Will, who are lawyer legislators. And there is a spectrum of beliefs. Some of them like the status quo. Some of them they're open to change, but they're not quite sure how far they're going to go. And there are other lawyer legislators who are strongly advocating for the reforms that I'm advocating for, and I'll let them speak for themselves. So I don't want to typecast lawyer legislators, but what I am advocating for is a system where when people see a lawyer legislator walking into a courtroom, that they believe that judge doesn't have any more influence than the prosecutor or the attorney on the other side. And right now, people don't believe that. And here's the thing. It's not fair to the judges, and it's not fair to lawyer legislators who are doing the right thing. I've spoken to current and former judges who said that when a lawyer legislator walks in, they are nervous about ruling for them because they know people are watching, and they're afraid that a ruling for the lawyer legislator would make them look like they're shilling for them, even if that's the ruling they would do for any other person. I've had lawyer legislators go in and I know them. I've seen them in court. They don't throw their weight around. They just go in there like a regular attorney, and people say, well, because you're a lawyer legislator, you must be, putting influence on judges. So I don't think it's fair to any of the parties. The people who suffer the most are the people, and specifically victims of crime. Victims of crime is really at the heart of this. So I want a system that when a victim of crime walks in there and the criminal defense attorney on the other side is a member of the General Assembly, that I don't have to explain to them or have to basically put my arm around them and have my victim's advocate console them, because when the judge rules, that victim believes it's only because of who the defense attorney was.
And we've talked offline about this. And one thing I did want to ask you, because obviously I made a little joke about the next governor there, but you don't, in our conversations, I've never perceived you to be very sensitive to the political component of this. You've been, whether I've been critical of your position or complimentary of your position, it hasn't really been a political question. How do you deal with the political nature of it? People who say, well, you're just pushing this because you're in a catbird seat to be governor, and perhaps that would benefit you from expanded power if you do assume that office. How do you react to people who level those kind of criticisms?
Well, there have been so many issues that came across my desk over the last 10, 12 years as Attorney General that were the right positions to take. I mean, we created with the help of the General Assembly, thank you, the Human Trafficking Task Force. And we were one of the worst states in the country on combating human trafficking in 2011. In 2012, we became the gold standard when we passed and implemented and executed the state task force. And now we are the gold standard for other states to look at. People are coming to us trying to replicate our human trafficking task force and the efforts we've made to reform how we go after human traffickers. I was out there working with the General Assembly, leading the best I could on domestic violence reform and how we go after those who abuse their domestic spouses and fought for that. And that was 6-7 years ago. DUI reform, worked on that. Internet crimes against children task force. We have grown that from 44 to over 115 law enforcement agencies out there protecting kids from predators and pedophiles. So I look at an issue not based on what it does for me, and this is something I want to say. As the Attorney General, and I think most elected officials would say this, but especially as the Attorney General, there's a V on every pleading, state versus so-and-so or so-and-so versus the state. No matter what position I take, I'm upsetting half the people in the room because they're on the other side of the V, the versus, right? And so I've just decided a long time ago that I'm going to have a clear conscience when I sleep at night. So I'm going to upset people by taking positions, and people are going to say I'm only taking the position because they perceive it as politically advantageous to me. But if I don't take that position, I'm going to get attacked by the other side. So no matter what I do, what position I take, I'm getting attacked. And so are other solicitors and sheriffs and legislators who take controversial positions. So just do the right thing and let the rest work itself out in the wash. So I don't worry about the future. What I'm worried about is the present. And right now in the present, we don't have as good a system as we could for electing judges.
Well, and I tell you what, if that system can change and it benefits you politically, that's great. More power to you.
If it benefits victims,
yeah.
If it benefits people who appear in courts, that's who it needs to benefit.
You've been very generous with your time today, but before you go, I wanted to ask you one more thing. I think I told you this story when we were down in Walterboro for the big double homicide trial of now convicted killer, thanks to your office and your team, Alec Murdaugh, was in the parking lot with a woman. She was not from South Carolina, but she'd been watching the trial the entire 6 weeks. And this was the day that you examined Dr. Kenneth Kinsey, the forensic expert for the state, some critical rebuttal testimony in this trial that really went a long way in convincing that jury to find Alec Murdaugh guilty. But this woman apparently had seen you in court that day, came up to me in the parking lot, and she said, you know that bald lawyer they had up there today, the Attorney General needs to use him more. I was like, ma'am, that was the Attorney General. This woman totally surprised. But tell us a little bit about that, not only that 6-week trial, but your time there in the courtroom during that just trial of the century.
It was a trial of the century. And first, before I say anything, the men and women on that prosecution team, men and women at SLED, our partner agencies, the Colleton County Sheriff's Office, DNR, Beaufort, all of them, thank you. Law enforcement, they got attacked a lot during the course of that trial. And I just want to say, if it wasn't for their hard work, listen, nothing's perfect, but they busted their butts, and I give them all the credit. Now, as to my small role in it, I went back and forth for 6 months as to how much of a role I should have in the trial. And I had appointed Creighton to be the chief prosecutor of it and said, build out your team. I'm going to support everything you need. But during the courses, the last thing I wanted to do, Will, and I've seen other AGs stand up in court and try to do something, and it just kind of blew up on them, and and it hurt the case or it hurt them. And I wasn't really worried about hurting me, but I was worried about, I wanted to win this case so bad because I believed and knew in my bone marrow that Alec Murdaugh murdered his wife and son, and that people in that community and around the state and probably around the country believed that this region was not going to bring justice on behalf of those people who were murdered because of who that individual was. And I wanted so desperately to reinstill people's faith in the criminal justice system. And I kept thinking to myself, if I show up in that courtroom, then people might impute motives. They'll say this is a political thing. If I don't go down there, they're going to say Wilson's incapable or Wilson's shirking his response. I get attacked if I don't go. If I do go, I get attacked. If I take a prominent role, it's because I'm trying to showboat. And so I didn't want to do anything to hurt the case. So I kind of stayed in the background at the early stages. It was right after Christmas where I told Creighton that I was probably going to come down there and support the team, but I probably wouldn't take an active role. So I got there. I couldn't be there for the first during jury selection and the openings, but I was there for the last 5 weeks of the trial. And what I basically told Creighton, and I kind of made a joke. I said, Creighton, I know I'm your boss. I'm FDR. You're Eisenhower. Okay, you work for me, but I'm not gonna micromanage this case. You make the calls, and I supported that because I felt like and I needed his team to know that. So my job was there to support the team, also to lend effort where I could, but also show the state how important this case was by personally sitting there for those 5 weeks. As the trial went on, I became more comfortable. Like I felt like I'd been baked in, that if I were to do more, that it wouldn't hurt the case because I'd been there. And I felt more comfortable. I didn't want to take a witness originally because I just didn't want it to hurt the case. I didn't want people to say, I don't like Alan Wilson personally, so whatever he's doing, I'm going to hold it against the case. I didn't want that to happen. So as we got deep into the case, I went up to Creighton and Don and some of the other folks and said, hey, listen, y'all, I'm a lawyer. I was a career prosecutor before I became the Attorney General, and I know this case well. If I can be helpful, let me know. And it just so happens that they said, yeah, why don't you take it? We'll focus on the closings. And so I ended up getting the last witness in the trial, who was Kenny Kinsey, who's an amazing individual. But I basically took that case, or took that witness, and did my thing, and it was there to support the team so that they could prepare for the next big thing, which was the closing argument. I was honored to be part of it, even if it was a small part. I was honored to support the team, and I'm honored to lead the office that brought justice to Paul and Maggie, and I'm honored to have led an office that played a role in what I believe reinstilling faith in people as it relates to the criminal justice system. This is another reason why I'm so passionate about judicial reform, because all the work that we've done to renew people's faith in the criminal justice system goes part and parcel with judicial reform. And I want to say one last thing, Will. I want to pivot back to judicial reform. It is important to me to know that I'm not attacking individuals. I'm not attacking judges. I'm not attacking legislators or lawyer legislators. I'm attacking the system. There are a lot of good men and women in the General Assembly in both parties who I think want to do the right thing, lawyer legislators and whatnot. And the system has produced a lot of the current system we have has produced a lot of judges, a lot of good judges. There are a lot of amazing men and women who serve.
Clifton Newman.
Yeah, and I've had people come up to me and say, well, in the wake of the Murdaugh case, this isn't the best time to go after judicial reform because this just proves, our point that we selected, the JMSC selected Cliff Newman. And I'm like, if you played Russian roulette one time and survived, is that proof positive that Russian roulette's a good thing to do? It's an anecdote. Now, first off, Cliff Newman would have done the right thing no matter what because he's an honorable judge. But the eyes of the world were in that courtroom every day. The eyes of the world are not in every single courtroom on every single case. And so that much sunlight, that much transparency in the trial, everyone was doing their best. And Judge Newman was an amazing gold standard judge. And just because the system produced great systems can produce bad judges, bad systems can produce good judges, okay? And by the way, there is no such thing as a perfect system. I'm not looking for perfection. It doesn't exist. As long as there are human beings in the process for electing judges, there's going to be politics and imperfections. We can't eliminate it, but we can make it better than we have now. So with that being said, that is kind of what's got me fired up. I came back off that trial kind of excited, renewed, reinvigorated, and I'm not letting this one go. And I appreciate, you for ringing the bell for all these years. I know there's a lot of other solicitors out there I've been traveling with, sheriffs, legislators. You're going to be hearing a lot more about this issue from me in the months to come.
Well, I hope you'll be willing to come back. And, we had a ton of stuff I wanted to get into. You've done a ton of work battling the federal government, some overreach on the part of the Biden administration. We didn't get to talk about that. A lot of other stuff happening at the state level, fentanyl. I know you've been working very hard on that with law enforcement partners. Will you come back and sit with us again at some point?
Of course, absolutely.
General, thank you.
Thank you.
Catch you next time, folks.